All right, that's our sign. I remembered to record. So welcome everyone. It is right at 9 o'clock. I know people are still logging on. We are expecting a lot of attendees on this webinar today. As always, Jen draws a huge crowd with all of her information. So we are going to get started. Hopefully everyone can keep logging in while we're doing the intro. So we do have Jake Mangas from the Reading Chamber of Commerce and Todd Jones with us from Shasta EDC to just say a few quick words to you guys. Jake?
Hey, thank you so much, Michelle. Really appreciate it. I don't know, can you see me right now?
We can.
Okay, great. I'm out in the field today supporting the Sierra Cascade Logging Conference, and I just wanted to say how grateful the Chamber is for this ongoing partnership, connecting our membership and beyond with the experts in the field. And certainly when it comes to O2 employment services, you guys are the experts in employment services as well, and including the HR updates that we do every year. And I think for a few years in a row now, we've been able to offer that at no cost to the attendees. So I want to thank yourself as a board member of the Reading Chamber of Commerce, Heidi Corrigan as a board member emeritus, and Jennifer Cram for cramming all this information into our brains today. And hopefully we'll retain enough of it to make a big difference and move the needle in our community. So again, from all of us at the Chamber, thank you so much. One of our, partners that we share is the EDC. And Todd Jones. Todd is also on the board of the Chamber. He is a colleague and he's also a friend, and it's my privilege to introduce him now. Todd.
Thank you, Jake, and thanks, Michelle and Jennifer, for being here as well. It is always a pleasure to be here. Although some of this content is pretty heavy, I'm very grateful for O2 Employment Services for being able to put this on and keep us up to date on what's happening with all the labor laws and some of the other topics that we're going to cover today on employee retention strategies and things like that. If you don't know, there's a lot of folks on this call, and some of you may not know. Reading MSA, and when I say Reading MSA, I represent the entire county on behalf of all the municipalities for the Shasta EDC for economic development. And oftentimes I'll use the phrase Reading MSA, which is the metropolitan statistical area. So that's kind of the Reading, Shasta Lake Anderson entire area, excluding the Intermountain area, but it's kind of the core of Shasta County. And the Reading MSA in 2021 was the only MSA in the entire state of California that added net new jobs from the end of 2019. So throughout the pandemic, we've been able to weather the storm better than anyone else in the entire state of California. And I know most of you on this call, I'm sure every single one of you is having problems hiring employees right now, finding employees, keeping employees, let alone all the labor laws that you're dealing with. So O2 obviously does a great job. We're grateful for what they do, not just for this, but for all the businesses in the community that they serve. But we do have brighter days ahead. We are growing, and I know sometimes it can be painful with some of the challenges to find workers, but having something like this just to give the updates and help you be more competitive and help you get that edge on hiring people and keeping people, it's super helpful. So I'm super grateful for O2 support and the Chamber support, and this is really what makes our community special, all of us coming together to do stuff like this. So thank you again for putting this on, and I'm always excited to be here.
Great, thank you guys. And I mean, as you guys know, those of you, I know several of you have attended these webinars throughout the years. We've done more of them since COVID than I think we ever did before. So it's a lot more information than we've ever had to absorb from an HR standpoint. But we're super appreciative to the Chamber and Shasta EDC for their ongoing collaboration with us. And, all three of us as organizations really work hard to support the business community and business owners and managers with information and resources. And we know how critical that has been, especially in the last 2 years, which have probably been the hardest years in business that most of us can remember. Just a quick note about O2 Employment Services. If you're not familiar with us, we are a staffing and recruiting agency as well as an HR outsourcing agency. So we actually are the HR department for hundreds of businesses, not just in Shasta County in California, but we also represent Oregon and Nevada as well. So lucky Jen gets to know all the laws for all of those states, not just California. Although if you can master California, I think Jen will tell you the other ones just don't seem so bad. And so that's from our standpoint, we really spend all day, every day, living and breathing the new legislation, changes in HR, helping our clients through that. As you know, everything with HR, staffing, and recruiting deals with people. And so while the rules and the laws may say one thing and your handbook may say one thing, each situation is unique and complicated and a little crazy. And so that's where we step in to allow small businesses to have the same resources that large corporations do by having an HR department of 25 people, essentially. And while that seems massive, that's about what it takes in the state of California to get by these days. So with that, I am going to hand you guys over to Jennifer. She is going to fly. Oh, I'm not, just kidding. I'm going to do my next slide and then I'm going to. So as always, I will be emailing out the slide handouts and the recording since I remembered to hit record this time. So we're already off to a great start. I will be emailing those out to you guys after the webinar. Everyone will remain in mute during the webinar. So if you're trying to talk, feel free. We will not hear you. Please use the question and answer section rather than the chat to ask questions. We will answer as many of them as we can throughout the webinar, but then we will also try to answer some live at the end. If we don't get to your questions, all of our contact information will be at the end of the slides. Most of you probably have it as well. It can be found on our website. You can Facebook message us, text us, call us, email us. We're definitely here to help. We want to make sure that if there's a situation or a question that you guys have and you need help with, please reach out to us. And with that, this part's Jen. So I'm going to go ahead and turn it over to her. Jen is our Director of Operations at O2 Employment Services. I would read your profile bio, but it is intense and long and super impressive, and it takes a long time that we don't have. So Jen, go ahead and take it away.
Well, good morning, everybody. As Michelle said, I'm Jennifer Cram with O2 Employment Services. While I might be the director of operations here and benefits, I also am an HR consultant, and I love helping our clients, and I love taking care of them and making sure they understand the rules. It might mean that they don't go with the rules all the time, but it means at least they have the information, right? So super excited to be here today. As always, Reading Chamber of Commerce, Shasta EDC, we love working with you guys. We couldn't do it without you. These last 2 years, as everybody has already alluded to, have been insane. And trying to make it through alone has definitely really not been an option. I think we've all really come together as a community, as an employer, small businesses, as well as employees, trying to figure out what the next steps are and how we can take care of our people and take care of our businesses and stay, operating. And with all the rules that constantly change every minute of every day, it makes it almost darn near impossible. So one of the things I'm super proud about is that O2 Employment Services has taken the stance very early on when COVID struck, was making sure that our communities have been supported. And that doesn't mean you have to be a paying member of our services. While we would love to have you on our team and we'd love to support you, we also understand that there are a lot of resources we, through hours and hours and hours of deciphering law and looking at things, we have the knowledge. And we want to share that with the community because knowledge is power, right? And if we can keep the community going and businesses up and operating, that's the name of the game. So super excited to be here today. As always, I'm super sad to not be in person. I am a people person and I love to see people and see eye contact and make sure I'm connecting with everybody because some of this stuff is a little crazy. Back to my little disclaimer, we're not attorneys. We try to make every effort of knowing as much as we possibly can, but we also know our limitations. There are times we're going to say you have to consult legal counsel, and there are certain situations in which you just have to make sure you have a good attorney because some things are a little tricky. And we want to make sure that you're doing it right and point you in the right direction, but sometimes that might mean you need to reach out to your counsel. So with that said, today we're going to talk a little bit about COVID-19. Actually, that's probably going to be the bulk of what we talk about today. Just kind of updating you with the newest, latest, greatest. There's been a lot of changes with CDC, with CDPH, with the ETS, which is the Cal/OSHA Emergency Temporary Standard. We're going to talk a little bit about housekeeping stuff regarding wages and minimum wage and all that good stuff. Harassment, discrimination, retaliation, some wage and hours, some arbitration. Michelle's going to talk about employee retention, so stay tuned. Make sure you stay after all the boring stuff that I go over. She's going to talk a lot about employee retention and give you guys some tools and tips, which are really important, especially in these trying times right now. And then we'll follow up with some questions. I'm going to blow through this stuff as quickly as I can because I have a lot to go through, and I want to give enough time for Michelle as well, because I can talk forever and then people go, okay, move it along. All right, so we're going to get started with some COVID stuff. So as we know, federal OSHA has gone ahead for large employers and said, you know what, we're not going to make the mandate happen, meaning that you have to be vaccinated or you have to do the 2 exemptions that are allowed, which is huge because I know a lot of employers that were over 100 were really perplexed on how they were going to manage this, how they were going to navigate this, how they were going to make it happen. So the good news is it has been overturned and we are not going to see this hopefully again. There hasn't really been any talk about it continuing, and Cal/OSHA has said they have no intentions of adopting or making any mandates. So that's good news, the good news, all right, the silver lining. However, federal CMS, which governs, Medicare, Medicaid, a lot of healthcare professionals, they accept these insurances and they accept them as payment from the federal government, and they have changed the rules a little bit. The good news is if you're in California, you've already followed this if you're in healthcare, because California Health Department has already put in rules back late last year. So a lot of businesses have already been complying, but CMS has come out and said, here's the federal rule. You're going to have to make sure that your healthcare facilities are covered. This would be important for businesses that are maybe home-based in California, but have other businesses in other states. The rules are slightly different, especially about boosters and about what is considered fully vaccinated. So pay attention to those rules if you're operating in other states. But if you are in California, you're already following this. California came out with their own rule, imagine that. And most employers have already been taking care of this and making sure they've either had their employees fill out the exemptions, which is either medical or religious accommodation. And now there's a requirement that boosters need to happen, especially in California. Like I said earlier, federal rule, boosters aren't considered fully vaccinated, but in California they are. There's been a March 1st deadline for the boosters that was just extended out recently. So if you're in the healthcare industry, you want to pay attention to make sure you're doing this. When we get to some of the exclusion rules and so forth, the health industry definitely has some different rules regarding that. Imagine that. All right, so Cal/OSHA regulations has some definitions. So the ETS, which is the Emergency Temporary Standard from Cal/OSHA, was updated in January of this year. It was kind of long awaited. We're waiting with bated breath, trying to figure out what in the world California OSHA was going to do. We know federal OSHA has, their blanket of what their requirements are, but California always decides to do something a little special and a little different. So they have updated their regulations, and it's going to be important that if you're a business owner in California, that you're making sure you're updating some policies, and we'll get to those things in a minute. But with that said, there's some new definitions regarding what the rules are in the Cal/OSHA regulations. Employers have to have documented from the employee received at least 14 days prior the complete vaccination series. So that means you have to collect data on your employees about their vaccine status, meaning when their first one was, their second one was, and when they're booster eligible or when their booster was. It also has some definitions regarding mixing and matching vaccines, which can be done. Some employees have chosen to, maybe start with Pfizer and end up with Moderna, and vice versa, or J&J. There are some acceptable forms of documentation. So the employee needs to provide proof, right, that they've been vaccinated, whether that's a copy or a picture of the vaccine card, and the employer is supposed to keep this. I know we're now medical providers, so we're keeping some medical records on employees, which means those need to be kept completely separate from your employee file. So make sure you keep that in mind. The employees can self-attest their vaccination status, and you need to keep it on record. So some employers decide to just have the employee fill out an attestation form, which is fine, but we should also make sure that those attestations are updated to include the dates and doses received and used in the workplace. This is important for exclusion. So when an employee has an exposure or comes up positive, there are some rules around vaccines and what the employer is required to do. Cal OSHA also defined what face coverings after 2 years are. So face coverings are 2 layers of fabric that do not let light pass through. So usually it's a double layer mask, usually surgical masks. I know there's been a lot of conversation regarding the N95 masks, and there's some guidelines around those as well, but it must cover the nose and mouth and secure to the head somehow. So even behind the ears, we have found is okay. Some end up back behind the head and all kinds of things, but there can't be any large gaps on the side of the face. So along the face, you can't see light through or have big gaps. And I know sometimes those masks do. And a lot of people have gotten the really cute, fancy ones, or maybe, your Steelers, maybe because I'm a Steelers fan, masks, but you want to make sure that you're following the guidelines with those. You can have a clear plastic panel when necessary, especially for communicating with those that are deaf or hard of hearing. Those are acceptable. I would be cautious and careful when you're allowing employees to do that. Sometimes they ask for an accommodation request because of claustrophobia or something like that. So make sure you walk through that interactive process with them. All right, also work site has been updated as well for purposes of exposure. This expressly excludes employees working remotely at home or another remote location selected by the employees. So some of these guidelines don't apply to people that work strictly at home. And I think since COVID, a lot of people have moved, to the home setting and are working from home. They're not coming into the workplace. If they come into the workplace, that's a little different situation, and you probably are going to need to make sure they're vaccinated or unvaccinated and do their attestation. And they might be required to do testing requirements and those kind of things. But if they're strictly at home, OSHA has kind of updated this, which is good news. It also excludes locations where one employee works alone. So if they work completely by themselves in an office space, then they might not have to worry about these things. They've also updated the rules about COVID-19 tests. We've seen a lot go around about the antigen, about the PCR, about what's acceptable, what's not. The interesting thing with the Cal OSHA regulations is it says that it does not include home tests that are both self-administered and self-read. Okay, so I'm at home and I'm doing my own test and I'm reading it myself because I have, the little instructions next to me. They're recommending that you have employees either FaceTime while they're taking the test to take it as an actual, readable result. Or we've kind of gone along the lines of an employee taking a screenshot with a date stamp and time on it that they have taken it at home. It gets a little dicey and a little bit, but sometimes I also feel you have to kind of do what makes sense for you. The CDPH guidelines apply when there are shorter than Cal OSHA guidelines. So CDPH, which is the California Department of Public Health, does have some different guidelines regarding healthcare workers. So if you're in the healthcare industry, your guidelines are going to be a little bit different than what Cal OSHA has published. So you want to be mindful of that. And this is where it gets tricky because we have CDC, we have federal OSHA, Cal OSHA, we have county guidelines, right? And we also have state guidelines. And we always have to figure out which ones are the most strict because those are the ones we end up following. And that's where we kind of come into play from an HR standpoint because we actually research all of that. We have to do it for all of our clients, depending upon what state they're in, what county they're in, what federal guidance comes down the pike. it makes it a little complex. So you're always going to want to make sure you follow the most strict rules. And sometimes that can differ from even Calos's rules and Shasta County's rules, or Yolo County's rules, or Sacramento. We have clients all over. So we're always checking the local ordinance as well. Anyway, but with that, if you're in the healthcare industry, there's a little bit different guidelines as far as exclusion from work. And when we exclude from work, that means we've had a positive case, meaning the employee, they're test positive, they've been at work, they haven't been at work. There's all kinds of stuff that you want to make sure as an employer, you kind of get to the bottom of. But if you have a positive case, regardless of vaccination status or symptoms, you're excluding them for 5 days. Doesn't matter. They're fully vaccinated. If they're unvaccinated, or they've had 1 dose or something like that, they're positive, they're staying home for 5 days. You're excluding them from the work site. And finally, Kalosha kind of caught up with what CDC did. CDC, I think it was towards the end of December, came out and said, hey, great news, everybody is excluded for 5 days, but everybody else county-wise were like, well, wait, we're still at 10 days. We're still doing the 10-day exclusion. So it made it a little complicated, but Kalosha's caught up. Most of the counties have caught up as well. So the 5-day rule is pretty much rule of thumb. If they have no symptoms and they test from day 5 or later is negative, the employee can return to work. So that's the good news. The exclusion's not 10 days like it was, or gosh, remember back in the day, 14 days? That sounds really weird to say, 14 days. But now we're down to the 5, so they can return to work. And if the testing is refused, so if the employee chooses not to test, then they're out for 10 days. They can return to work on day 11, assuming that they have no symptoms. And they must wear a well-fitted mask for the next 10 days. So if they test negative day 5, they come back to work, they're wearing a mask. They're in the workplace, they're wearing a mask for 10 days. All right, close contacts. This is where you're going to do an intake form. So you have an employee that calls you, says, I'm positive. You kind of say, okay, so when did you become symptomatic, or when did you test positive? Let's go back a little bit. Let's see where you were the previous 24 hours. Do I have any exposure to any other employee in the workplace? Or was it over the weekend and you were out at a party and you didn't come to work Monday because you tested positive Monday morning? So the close contacts from a workplace standpoint, you don't really have to do a whole lot for your employees other than keep that employee that's positive out. However, if you discover that there are employees that might have exposure at the workplace, then we have to kind of go through the gamut of saying, okay, what was their vaccination status? And if they're fully vaccinated, remember, fully vaccinated means including booster, or are they booster eligible? And we'll get to that in a minute. Then we'll have to kind of determine, and that's why it's important to know kind of the status of where your employees are at. But if they're not vaccinated, they would follow the asymptomatic positive rules. So they're out for 5 days, test on day 5. If they have no symptoms and they have a negative test, the employee can return to work. And they, again, must wear the face mask for at least 10 days around others. Even though in California, we have the indoor mask rule. So we'll get to that one in a minute, but they definitely should be wearing a mask even while at their desk. I recommend that they just wear it continuously while they're in the workplace. So if you have a vaccinated but not boosted, though maybe they're eligible for the booster, they've chosen not to get the booster, or they just haven't gotten around to doing it yet. Generally, that would be the same requirement applicable to an unvaccinated employee. So you're going to follow those same rules. There is an exception that employees remain symptom-free and test negative on day 3 to day 5. In which case no exclusions required. So you can take the risk of having an employee return to work, and as long as they're negative day 3 through 5, you can have them come back to work a little early. However, they still can become symptomatic and you might have exposed everybody at your work site. So it's kind of one of those things that you want to be mindful of. But there's sometimes that you've got a very limited staff, or they have no symptoms, they're not sick, they just tested positive because they had to go to an event or something, and they all of a sudden come up, but they feel totally fine. Vaccinated and boosters. So if you're completely technically vaccinated and boosted, there's no exclusion. So the employee can return to work, but they must wear a face mask for at least 10 days. So some of that fun stuff. So some miscellaneous things regarding the regulations: an employee who has a medical exemption from wearing a face covering. So you've done the interactive process, you've talked to the employee and they're like, I'm not able to wear a mask, type of thing. So if their condition does not permit them to wear a non-restrictive alternative, they must socially distance and either be fully vaccinated or undergo weekly testing. So if you've done an accommodation process where people can't wear the confined masks, they're wearing a shield or something like that. There are some guidelines that go around that they must socially distance, which we know is 6 feet, or be fully vaccinated and undergo weekly testing. No testing exception for fully vaccinated employees during an outbreak situation. So we've talked about outbreaks before. We're not necessarily going to go into that a whole lot today, but an outbreak is 3 positive cases in the workplace within a 14-day period. So with that, employees are supposed to be tested, and it's at the expense of the employer. So if that happens and you have a fully vaccinated employee, they still need to be tested. Expanded outbreak testing requirements for an employee residing in an employer-provided housing. There's some additional requirements around that if the employer provides housing for employees. So what are the next steps? So what do we do now that we have yet another piece of a document that we need to make sure that we have updated, right? So we have to update our COVID-19 prevention plan. So last year, I think we all inundated with this thing called the CPP, the COVID prevention plan. It goes alongside with your IIPP. I know it kind of sounds like alphabet soup, but your IIPP is your injury and illness prevention, which is really what OSHA stands for in a lot of ways, is making sure the workplace is safe for employees to be in. That's the bottom line. That's why OSHA's really gotten involved, because this is a disease that, is communicable, and they want to make sure that they keep the workplace safe. And doing so, they've created this prevention plan that gives guidelines for employers to say, this is what I do when I have a COVID exposure. This is what happens, how I'm cleaning. This is, how I'm excluding people. If I'm excluding and it's a workplace situation, what's the exclusion pay look like, which we're not going to get into today, but I'm happy to discuss if you want to know more about exclusion pay. But you also have to make sure that you revise the guidelines for excluded employees, because they've changed and allowed that people that work from home don't necessarily have to be in the same guidelines as before. Making sure that your documentation for your vaccine status, especially if you're using the shorter CDPH exclusion timelines for close contact, you need to make sure that you have updated those. CalOSHA, actually, you can go to their website and they have a template, and you can kind of go through and curtail it to your business, which is what we recommend doing, because it's straight from the CalOSHA website. I'm going to tell you, if CalOSHA comes in and asks to see that, you better be able to produce it. So I recommend you get on there. It takes a little bit of time to go through, because there's specific stuff to your business that you're going to need to update. And even for our clients, we give them as much as we can. There's still some stuff that they're going to have to do because it's their work site. Self-attestations, if you're using those, make sure you include the vaccine doses and the dates, and including the booster. So making sure you update your forms. There's a bunch of forms that need to make sure that they're compliant with, especially the current regulations, such as this AB 654, which amends the AB 680. I know it's not like you guys are really excited about all of these numbers, but we in HR kind of get excited about them. I don't know why. But basically, a work site must be updated to match the CalOSHA regulations. So any work site that you have, you need to make sure these CPP guidelines are there. Excluding the remote home work site and work site where one employee works alone, updating that. But it also updates the fact that employers must provide written notice of exposure to any close contacts, not just exposed worksite group. So AB 680, which came out last year, is a notice. It's called a model notice that goes out to all employees that might have been exposed. Doing your contact tracing, you kind of figure out, okay, I have 6 employees that worked closely, meaning 15 minutes or more, 6 feet or less, masked or unmasked. We need to exclude them from the work site because they're not vaccinated or they're not fully vaccinated. And you had to provide this model notice to them within a 24-hour period that says, hey, you've been exposed, here's your benefits. If you come down with any symptoms, this is what it is. That was a requirement. And so you had to get that notice out to all employees that might have been exposed. Well, AB 654 has been updated to say, you know what? I don't care who was really exposed. I want everybody in the workplace to know. So this is where it gets fun, because you might have vendors, you might have consultants that came in that are not necessarily your employees, but might have had exposure to the employee, and you're supposed to notify them. The notice of the members that are exposed worksite group must include the information about your COVID-19 benefits. Are you paying? Are you not paying? What are they entitled to? Is there exclusion pay? Is there unemployment available to them? Disability? And what does your cleaning and disinfecting plan look like? So those are all things that are included in this that you need to have updated. We recently just updated ours to include a lot more of this stuff. They actually extended the outbreak period to local health departments. That was from 1 day to 48 hours. Thank you. Gave us a little more time to get that information into the public health departments. I believe the model notice is still maybe the 24 hours. I'm not 100% on that. It might be the 48 hours as well, but we try to just get it out as soon as we're notified that we've got situations going on. There are certain exemptions for certain CDPH licensees. So healthcare facilities under the Health and Safety Code 1250, adult day healthcare centers, community clinics, community care facilities, and child daycare have some exemptions around this. So if you're one of those facilities, you have different requirements regarding the AB 654 form. All right, supplemental paid sick leave. We thought we were done, but we might be back in for it. And I'll go over those in a minute. But right now, as we all know, emergency paid sick leave, both federally, the FFCRA was gone back in September. California also said, hey, we're not doing the sick leave anymore. So that expired September 30th. Some municipalities and local requirements are that you still have to pay. It just depends on your employer size and where you're at county-wise. It says the state may not adopt additional requirements, and there's none yet, but please hold, because there is a proposed bill out. And I think a lot of you have probably already heard about this, because people have kept calling and saying, hey, I heard that there's going to be a supplemental sick leave. And we're 99% sure this is going to pass. It has not been signed yet, so it's not necessarily in effect. I'm just giving you what's proposed right now. This actually came out earlier this week. There's been some legal stuff that went around last week and the week before that kind of said, hey, just letting you know this stuff's going to happen. But right now, the proposed bill looks like it's going to be retroactive to January 1st of this year, which means if you've had employees out that have not been paid exclusion pay or something of that nature, they might be eligible for this supplemental sick leave. It right now says it's for employers with 26 or more employees. So that might be a blessing for some of you guys. However, it doesn't mean if you have less than that, you can't adopt it. You can still continue to pay if it makes sense for you and that's what you want to do. Full-time employees would qualify for up to 80 hours of leave. There's actually two banks. The way that it's written, it has for if you're sick, basically, and then if you have a sick child or you're taking care of somebody or there's an exclusion of some kind that you've had exposure. So there's two different banks. So 40 hours for one time and 40 hours for another. Variable houred employees, such as part-time employees or employees that work for you sporadically, have a look back period. Right now it's at 90 days, which is very similar to what we saw with the California required sick leave. Federal, of course, was like 6 months. And so we had two different calculations going back and forth as far as variable houred employees, but it looks like it's going to follow the California guidelines of what was previously done. Right now, there's no tax credits. However, I have also read that there's another bill out there that is trying to give employers some type of tax credit. So this might be really beneficial and helpful for small businesses because I know it's just one more thing. You're just trying to get back up and running and now you got to pay for all this sick leave. One more requirement is that it must be on the wage statements, not like it was before, because of course it can't be the same. It really is saying that you need to make sure you report on the wage statement, which is their paycheck stub, right? How much time they took. You don't necessarily have to keep the bank of hours and keep track like we were. So you have 80 and they took 40 and now they have 40 remaining. It looks like you're just going to have to put on the pay stub what the employee took that pay period. So might be a little more administratively less burdensome, but we'll see. There is a notice that is required that needs to be hung in the workplace that employees know that this is available to them. And then once the bill is signed, it goes into effect 10 days after. So we have a little bit of time, but not really a lot of time. So we'll keep you updated. Always check in with us. We're happy to share the information as we find out, because it's just a moving target and we're not sure exactly when or if, and it could have been signed right now. I have no idea, but as of this morning at 6 a.m. when I checked, it had not been signed. So we will just stay tuned, right? And just see what happens next. One more thing with Cal OSHA, the enforcement, they passed a Senate Bill of 606, which means there's enterprise-wide citations. So what this means is that if an employer gets cited by OSHA and they go into a business and say you're a restaurant and you have a franchise and you have 6 other locations, if that one location is cited and fined with any violation of the CPP or your ETS plan or your COVID, guidelines, and you're fined with whatever, they can apply it to the entire enterprise, meaning all your other locations will be fined as well, because they assume what you're doing in one, you do them in all. So be mindful of that. What you implement in one location, you need to make sure you stay global across the map. Common industries, this would include construction, chain retail, manufacturing. So keep those things in mind. The mask mandate right now is still in effect till February 15th. I read something yesterday, the CDC is planning on extending that through the end of March. I don't know for sure yet. We're not sure what California Health Department's going to do. We obviously have had an uptick of this Omicron, so I'm not sure how long that will, if that'll extend or not. But right now that is in effect regardless of vaccine status. Counties that will implement stricter mask requirements. So check your local county guidance, because those counties such as Sacramento, Yolo, Sonoma, they have specific mask requirements that you must follow. Here's an interesting little case that we recently came across. This was See's Candy, poor See's Candy. They were in another lawsuit many, many years ago that actually changed the way rounding methods are used in the employer setting. But nonetheless, this was a legal case that came out back in December regarding an employee that allegedly caught COVID-19 at work. She ended up going home and passing it on to her husband. And her husband ended up dying. He had other morbidities and he ended up really sick and he ended up passing away. So the employee sued the employer, saying that the employer was negligent in failing to take the steps to mitigate the COVID-19 spread, which ultimately caused his death. The employer argued workers' compensation was an exclusive remedy, meaning that workers' compensation only protects the employee. So with that, the injury to the husband was not a derivative of the employee's workplace illness. So workers' compensation statute did not apply. But this just goes to show you where things are going and how things can happen. And so it's really a word to the wise, just to make sure when you're staying compliant in your workplace, that you're following protocols, that you have things down and you're staying compliant as possible, that you're cleaning, you're disinfecting, you're doing things. Even though this case didn't necessarily go through, we're still kind of pending some results of that, but make sure that you're doing things compliant, because the last thing you want to do is say, well, we really don't clean. We kind of wipe things down with a little, Clorox wipe, but are you really doing a deep clean? Do you have an outbreak? Do you have a situation that warrants more? Are you doing everything possible? Right to recall, meaning that if you had employees that you laid off last year, especially March, April, May, we had so many employers that just had to close down. They couldn't continue. We were shelter in place. There is some limited exclusions, meaning that employers in janitorial, security, hospitality, and airport services, that you must bring them back to work. So you have to make sure that you've offered them a job. They have 5 days to respond and reply. This doesn't go across the board, but these limited exclusions do apply. So if you're of one of those industries, you're supposed to make sure you have the right to bring them back to work and you let them know. If they don't respond, then you don't have to bring them back to work. But if they reply and they want to come back to work, you better have a job available for them. There's also some local requirements that if you're in Los Angeles, Oakland, San Francisco, San Diego areas, you want to make sure that you're following those. All right, we're moving along, trying to keep this going here. I know that was a lot on COVID, and there's so much more that probably you guys have questions about. I'm happy to answer those offline. We can answer later. But in a nutshell, that's kind of where the landscape is at this moment in time. All right, we're going to roll through some of these things. You guys already understand minimum wage. We talk about this every year. Last year, we had $14 and $13 an hour if you're under 25. January 1st of this year, we are at $15 an hour if you're over 25 employees. If you have 25 or fewer, you're at $14 an hour. January 1st of next year, we're at $15 an hour all across the board, regardless. In January 2024, there could be an annual increase with the CPI inflation rate, but it'll be no more than 3.5%. So make sure if you're also working in other localities such as the Bay Area, Southern California, there's some other places, they have their own minimum wage requirements. So make sure if you're working in other counties, they also have sick leave laws that are different. There's like 22 different across California. Nevada has their own, Oregon has their own, requirements as far as sick leave and their minimum wage requirements. I know Oregon goes in July, so make sure you keep an eye on those. If you're paying an exempt employee, if they meet the guidelines of an exemption for an employee, they've gone through the test. There's a model test that you can kind of roll through to see if your employee actually qualifies for being exempt. If they meet that one requirement, you also have to match it with the minimum salary they can receive, which is double minimum wage. So those are there. Computer software employees exemption was increased to $50 per hour. So if you have computer software employees that are exempt, you want to make sure you look at that. The IRS mileage went up along with the gas prices. So anyway, we're at 58.5 cents per mile, increased from 2021, which was at 56 cents. SB 639 was updated or amended, which prohibits the issuance of a new special licenses for reduced minimum wage for persons with disabilities. So some employers, they hired people with disabilities and they actually applied for a license and they were able to pay them less than minimum wage. Those licensures will no longer be issued after January 1st of 2025, and they are no longer able to reduce the minimum wage. Wage theft. So this is probably one of the newer things that came out that struck me more so because it's a wage and hour situation. And this actually can be a very strong conviction. I actually believe it's tied to a felony conviction if an employer is found that they have not paid an employee intentionally. This doesn't mean necessarily you forgot to pay him some hours, there was a payroll error, you made it right, you fixed it, you went back and did it. That's not what they're talking about. They're talking about that you've withheld payment from the employees intentionally. You're trying to punish them, you're trying to make them bring back tools in order to, get their final paycheck, which is a big no-no. Employers can be charged any amount over $950. And for more than one employee, if they find that you have more than one employee that this has happened to, any amount more than $2,350 in an aggregate can be applied. This also includes benefits. So if you've denied an employee benefits knowingly or didn't offer them because you chose not to, this can fall under this category. This also includes payments owed to independent contractors. While they're not an employee, if you've withheld from them, they can actually go through and say that it's wage theft and file a claim as well. So be mindful of that. AB 1003 was amended. So last year, this is basically just a cleanup bill of Senate Bill 1383. It expanded the coverage for family members under the California Family Rights Act, right? Which is an employee can request, if you're an employer with 5 or more employees, you now have to give protected leave if the employee meets the requirements. But it also expanded this to include a definition of parent-in-law, but they neglected to include it as a covered family member for the actual leave through CFRA. So that's just a cleanup bill. They basically forgot something and needed to add it back in. Electronic workplace postings. This has been extremely helpful, especially with COVID and we have employees working from home. It now authorizes employers to provide required workplace notices electronically to employees. So if you have an intranet and you have a place that you can post your posters for those employees, or we have a portal through our payroll system that employees can get online and they can see all of the forms and the required postings. We have them on there. However, keep in mind, employers are still required to have hard copies in the workplace. All right, we're going to talk a little bit about harassment, discrimination, retaliation. There's a lot of legal cases in this, and I'm going to try to summarize some of them so that I don't completely bore you to death. You guys will have the slides. You can kind of read through the case law and see where things are at. But there are some things that I'll just kind of roll through and give you a gist of what it is, trying to spare you some of the gory details. However, this was one of the regulations, Assembly Bill 468 added some regulations regarding emotional support and animal certifications. So those that have, an employee that comes in that has a service dog or has some things, there are some requirements that are actually placed on the providers and practitioners that are issuing those guidelines. They have to have a valid license. Note the licensure is in documentation, so the notice that they give to the employee to give to the employer. They have to be licensed to provide professional services within the scope of the license and the jurisdiction where the documentation was provided, meaning that it's not necessarily from, another state or something like that. Those are always fun, but you need to make sure, you're kind of doing your homework as far as, if somebody comes in with an emotional support animal. Establish that the client provide a relationship with the individual seeking the documentation for at least 30 days prior to providing the documentation. So they're an established patient. They haven't been, just go into somebody one time and they decide that they need this. You can ask that they've been a provider or been with them for longer than 30 days. And complete a clinical evaluation of the individual prior to providing the documentation, which kind of goes back to not just a one-time deal. There are some other things that establishes the requirement of selling an emotional support dog. They obviously have to let them know that maybe they're not completely trained. There's documentation around this. If somebody's knowingly or fraudulently represents oneself to be an owner or a trainer of a canine licensed as, to be qualified as, or identified as a guide, signal, or service dog is a misdemeanor. So they're making sure that, people are legitimately having real service dogs. I know that's always been a very touchy situation. We had an attorney come in many years ago that talked about ADA accommodations and service animals, and it's not just necessarily dogs, right? And it might be an emotional support animal, and it could be a rodent, or it could be a cat, or it could be, there's multiples, and there's a whole process that goes through that. And, as much as we love going through the ADA accommodation process or, the interactive process, it's really important for employers to do. All right, record keeping on FEHA. So basically with retaliation discrimination cases, they have now extended the requirement for these employees. They can now, it used to be 2 years, they could file a claim. Now it's 4 years. So if they've been let go for a certain situation, they're claiming retaliation, discrimination, or harassment, they have 4 years to do this. You also have to make sure that you keep the records for that time. Most employers keep records for a long time. I always max them out and say at least 4 years. Some are 2 years, some are 3 years, some are 6, some are 30, just depends on if they're medical or not. But at least 4 years for your employee files. Because the employee can then go back and they need to, if they file a claim, you need to produce the records within a timely fashion. That also clarifies that the DFEH has up to 2 years from the date of the group or class complaint to complete the investigation or issue the right to sue. So the DFEH can go through and make a determination. The employee can go straight to them and file a little claim and say, this is what happened. DFEH goes through and they can, do their investigation, and they might say, hey, we're not getting involved. We don't have enough, but we're issuing a right to sue letter, meaning that the employee can go out, hire an attorney, and go in and present to you. Or the DFEH can say, yes, we find that this has some legitimate reasons that we need to go in, and we're going to do the investigation. So make sure you keep your records. Confidentiality and settlement agreements. It expanded the prohibition of confidentiality and non-disclosure provisions for discrimination, harassment, and retaliation claims. It's opened it up a little bit more. It used to just prevent sexual harassment. You could disclose sexual harassment and discrimination claims in settlement agreements, and saying that, you had a non-disclosure agreement that prohibited that. It now applies to FEHA discrimination, harassment, retaliation claims for an employment settlement agreement that was entered into after January 1st of this year. So if you have confidentiality and you have settlement agreements, severance agreements, okay, so you're basically telling the employee, here's, thank you for your employment, either you're retiring or we're terminating you. Make sure you have legal counsel kind of review these forms. These things are important to have the correct language in them, making sure that in one that you're not disclosing something you're not supposed to, or you legitimately can. It kind of gives you a little bit more that you can actually release to a next employer and so forth, but make sure you have the correct verbiage in there. Let's see what else we've got. Confidentiality. It prohibits any employment severance agreement from precluding disclosures about unlawful acts in the workplace unless the agreement is a resolution of a claim already presented by the employee. The agreement is voluntarily provided consideration to the employee, and the employee has had the opportunity to retain an attorney. So you've given them the ample amount of time to review the severance agreement. Right now, you're supposed to update those severance agreements to have at least 5 business days before they actually execute it. I know in the past, sometimes employees just waive, they sign the severance agreement because they want the check, and they'll take it right then and there, but you're really supposed to give them at least 5 days to take review and be able to present it to legal counsel if they choose to. So that's why I say legal counsel should update these and make sure that you're compliant, especially if you're terminating or separating with somebody over the age of 40. There are requirements as well. There's actually additional time that employees can take to review the contract and agreement. All right, so here's a couple of case laws. There was an employee that worked as a teacher. She experienced some chronic pain, headaches, nausea attributed to the electromagnetic frequency alleged caused by the school district's new wireless system. She was ultimately diagnosed with a condition called electromagnetic hypersensitivity syndrome. So the employee went back, basically asked the employer, hey, I need an accommodation. I can't work. Those Wi-Fi access points are just, causing all kinds of problems. At one point, the school had agreed to retain a neutral consultant to come in and see what she could safely perform, what she could do, but they ended up not bringing them in. Despite the repeated efforts, the employee could not return to work because every time she did, she was overcome with crippling pain. Therefore, she ended up filing a lawsuit alleging that the school district didn't do enough to do a reasonable accommodation. At first, it was sent to the court, and the court says, hey, you know what, we agree the school district did everything possible. There's no way that the employer could have done anything more. Well, the employee wasn't satisfied. They went on and they took it and they appealed it. And so they went on and went to court. And they actually overruled and said that the employee could have performed her jobs with a reasonable accommodation, possibly by adding some fabrics and paints over the areas of the electromagnetic field. And these would have been considered a reasonable accommodation. And so it ended up being a big litigious lawsuit. So as much as we love and don't love ADA accommodations or employees that have situations that come up, that need accommodation, those are the areas where I say if you don't have an HR department or you don't have somebody that you can talk to about leaves of absence, because they're a pain in the neck, because they're so lengthy, right? There's a whole process back and forth and paperwork and this, that, and the other. Make sure that you do the paperwork. Make sure that you've gone through the whole process. Make sure that it's reasonable. If you have an undue hardship, you better be able to prove it. So bottom line is make sure that you do the process and you go through the gamut. I know, it's one more thing. All right, so here's another legal case that went through. This is Freed versus Wynn Las Vegas. There was an employee who worked as a manicurist in a salon in the Wynn Hotel. The employee had a history of complaining that his female coworkers received more appointments than him because of his gender. He was male working on feet, and he was saying the female workers were getting more work. However, there was one day a male customer came in for a pedicure and asked him for a massage. And in the meantime, he had made number of sexual comments. So about 15 minutes after the employee was taking this sexual comments, from this other male employee patron, went to a supervisor and said, hey, I don't feel comfortable working on this guy. Like, he's making weird sexual comments, like it's making me feel uncomfortable. I don't want to go back and do it. Well, the supervisor basically said, get back to work. I don't want to hear about it. I think you need to just finish your job and do what you were told. So the employee returned and finished the pedicure, and the customer proceeded to make 5 or 6 sexual comments to the employee. Well, the employee filed a lawsuit regarding a hostile work environment regarding sexual harassment, among other reasons. The trial court granted summary for judgment for the employer, but then the court had appealed it and reversed it. They basically came out and said that this supervisor had been notified of a situation regarding a harassment situation and basically told the employee to go back into the work environment, even though the supervisor knew it was an uncomfortable situation for the employee. So it's a big no-no. So it created a hostile work environment for this specific independent situation. So it ended up going to court, and they filed a hostile work environment, and the supervisor should have taken immediate course of action. I'm interested to hear more about this case, about the personal liability the supervisor had, because they made the decision, right? But it also put the employer in jeopardy as well. Let's see, this was an age-related comment was made from an employer. There was an employee that was older and was working in an environment where they felt there was age discrimination because they hadn't been chosen for a position. And the reason the employee felt that they were passed over for the position was not necessarily because of the qualifications, but because of another person in the environment making a comment about a bias in age and how it generates, basically this employee was saying that older people shouldn't be in the workplace, and made comments regarding age-related situations. And because they were in an influential advisor position, the ruling kind of came back and said, well, where there's smoke, there might be fire, meaning that, if one person is saying this, are there other representatives in the company? Are they saying these things? Hang on, I think I went too far. I did, sorry about that. All right, so you need to make sure that your employees aren't saying something on your behalf. Here's another case with Dignity Health and Manor. There was an employee who worked as an engineer in a medical laboratory. His supervisor, who owned and operated the lab, also supervised another employee in which he was having a long-term relationship with, which began as a workplace affair while the supervisor was married. After the laboratory experienced a lack of funding, it terminated the employee for performance reasons and because the laboratory had funding problems. With that, the employee filed suit for a sexual discrimination, among other reasons, which the trial court construed as par preference, meaning that he had preference for the person he was, having the romantic relationship with, and they felt that they were being discriminated against because they weren't asked to be in the relationship. The trial dismissed the sexual discrimination claim based on a summary judgment for failure to state a cognizable claim, and the court then appealed the affirmation. They basically said it doesn't prevent the employer from providing favoritism towards a supervisor's sexual or romantic partner. The court reasoned with giving a preferential treatment to the supervisor's paramour is not discrimination against the employees because it wasn't of their sex. So it's also important to note that while such favoritism did not create liability under the theories alleged in the case, similar behavior could raise a hostile work environment sexual harassment claim under the California law. So just interoffice relationship shouldn't happen. All right, I'm running out of time, and I know Michelle's going to start texting me and telling me. So there are several other cases, but there was a couple that I want to make sure that we go through. So one of them is with wage and hour. So we're going to skip ahead a little bit so that I don't completely lose track of time and Michelle doesn't get her opportunity. Executive Order 14026, which was effective January 30th of 2022. Employees under certain federal contracts must be paid a minimum hourly wage of $15 per hour with an annual increase that's determined by the U.S. Secretary of State. So if you've got prevailing wage jobs and other jobs that you've got under federal contracts, make sure that you're paying your employees correctly. This case here talks about rounding, and which I think is really important. So any of you guys out there that use your employees, use the rounding rules with your punch in and punch out, make sure you don't do it on meal periods. Don't round meal periods. Actually, rounding in general, you should just pay to the minute. It actually keeps you in a safer. Back to the Seas Candy. That was one of the rounding issues, was their first case. But with this, it says don't round the meal periods, because especially if you're rounding down and up and it's not in favor of the employee, this employee ended up with a big chunk of change because it was paid incorrectly. So make sure if you're rounding that you're doing it correctly and that you've spoken to legal counsel. Let's see, meal and rest periods. So premium pay and regular rate of pay. So the law changed last year for California in particular regarding the regular rate of pay and how that works for premium pay. So in premium pay, employees are supposed to be paid in the event that they miss a meal or rest period because they weren't provided the opportunity. Employers are supposed to pay at the regular rate of pay and hour premium pay. Well, most employers, obviously, if they're paying premium pay, they're paying the employee correctly. It's not at an overtime rate. However, they've now clarified that the regular rate of pay must include any commissions or non-discretionary bonuses. So within that earned period. So right now, if you have employees that earn premium pay and you're paying them at their straight regular hourly rate, but they also earn commissions or non-discretionary bonuses for the pay period before, somebody needs to go through and figure out what the regular rate of pay is, because it now is adjusted based on their commissions or your non-discretionary bonuses. So make sure you're doing those correctly. We actually went through and did a lot of audits on employers that have commissions and bonuses, and to review what maybe the employee was not paid correctly. Let's see, pay your employees correctly. I'm going to skip through some of these. This was another case that an employee basically said he wasn't being paid overtime correctly. Just remember, the burden of the proof is always on the employer. So in the earlier slide, it says that the employee lost the time cards and they couldn't figure out what the commissions were, and they didn't know how much overtime that the employee actually worked. So they ended up winning the case, the employee did, because the burden's on the employer and the employer couldn't prove it. So make sure you're maintaining proper payroll and timekeeping for the last 4 years. Keep all that stuff together. Make sure you keep your time cards and make sure your employees fill them out and don't modify them, and make sure they sign off and have little attestations and all that good stuff. This is about bonuses and making sure that employees are being paid correctly. I'm not going to go through all of that. Also, make sure your pay stubs are up to speed and that don't rely always on your payroll company to make sure they're correct. The employer can be held liable for those if they're not taken care of. This Burlington coat factory was interesting because the employer actually made the employee sign a promissory note at the time of separation. The employee made a mistake. That was $880 or something like that. And they ended up firing her. She resigned from the position, but in doing so, they made sure she signed a little note that said she promised to pay back the mistake that she made. She let a coat go out the door or something happened. And the employee said, I don't have to pay that back. I don't have to, it was a mistake. And the courts actually favored in her favor, saying she didn't have to pay the $880. So if you're making employees sign a good faith or a note when they've separated with the company saying they're going to pay back for a mistake that they made, or, sometimes I've seen it where they've smoked in hotel rooms and they're making the employee pay for these things. Be very careful. You should actually, especially if it's a certain threshold, you should make sure employees, you go through legal, and file a different type of lawsuit or legal action against the employee. Don't take it out in an IOU or make them sign something. I am running out of time. Arbitration, I'm not going to go into a lot of this other than making sure if you guys do arbitration agreements, don't make it a condition of the employee's employment. All right. So you don't tell them they have to sign an arbitration agreement. It has to be voluntary. All right. You have to make sure that you tell them it's not a condition of their employment. If they choose not to sign it, they need to opt out of it. And a lot of employers, have employees sign arbitration agreements, which means that the employee, if they end up wanting to sue, they have to go to arbitration. You have to make sure that you don't coerce them or make them sign it or feel that it's a condition of their job. There's another provision in here about electronically signing them. Make sure that you have good measures in place if you're doing electronic onboarding, and making sure that the employee can't move forward if they don't sign the arbitration agreement. Make sure they have the opportunity to opt out of it, and make sure that it's in legal context of, typeset that they can actually opt out of it, because it is a legal documentation, making sure that the employee signed it. There's been a couple of cases, which I'll let you guys read through, that indicates that an employee says, well, I wasn't really filling out my electronic paperwork. My cousin was, and so they signed it for me, and it goes on and on. So just making sure too, if you're doing electronic ones, that you have a way to verify that the employee actually is consenting to the information. That case was actually thrown out. But just make sure you're paying attention to arbitration agreements, and especially with PAGA lawsuits, they're kind of a big deal. So make sure you have legal counsel review any of those. I'm not going to go through all of this because I know we are running out of time, and I'm going to let Michelle take it over. Thank you all.
All right, awesome. Thank you, Jen. So if you hear me say next, it's just to help Jen know when to move my slides. But as you guys know, I think I would have you guys raise your hands, but I can't see you. I'm sure everybody is experiencing problems with people not wanting to work, people not responding to job ads. But really what we've seen that is just incredibly unprecedented is the number of people that are walking off the job. So people that are, and it's all positions, it's all levels, it's all companies, people are just resigning from their positions in record numbers. And so we're going to talk about some employee retention tips. I will just say going into this, the key with any employee retention is individual. So I would love to say, I'm going to give you these tips and you're going to go out and use them. And then none of your employees are ever going to leave your company again, unless you choose for them to, obviously. But it doesn't work that way, because we employ people and each person is different, and what motivates them is different. What they want from the workplace is different. And so I'm going to give you kind of an overview that are some great things to keep in mind, and some great things for you to do and have your managers do, because their role in this is critical as well. But you do need to individualize this to each employee to the extent that you're able to. Jen, you can go to the next slide. So one of the things that I think is really critical in employee retention is just understanding people. Now, we have an unprecedented situation where for the first time in US history, we have 5 generations in the workplace. And I only listed 4 of them on here. Nothing against the traditionalists. So your traditionalists come before your boomers. So right now we have this massive age gap in the workforce, and each of those generations has a different kind of set of trends and circumstances that they follow, that and a different thing that they're looking to. But I don't know how many businesses I've talked to that have said, I've never had to do this before. Like, this is how we've always done business. This is what our culture has always been. And I have these employees that have been here for 40 years and they're fine and they're happy and they come to work and they go home and they're never a problem. And then I've got these new employees and they want to be my friends and they want fluff. And I have to tell them every day they're doing a good job. Well, this is why. Totally different generation that we're dealing with. And millennials and Gen Zers make up the bulk of the workforce right now. And that is going to continue. So I'm going to go into this a little bit. Obviously, this could be an entire webinar all in of itself, just in terms of what the different generations look for. But I highly encourage you guys, in all of your free time, obviously, to look into some of these trends. It's super interesting to see what each generation is bringing to the workforce, both in strengths and weaknesses. It's interesting to see what they need in terms of work and what they're looking for, what motivates them as a whole. Each person has their own individual motivations, obviously, and that's why I say you need to get to know your employees on an individual level. But it's super interesting and eye-opening to look into what each generation is bringing, what they typically need, what they're looking for, and when it comes to work fulfillment. And so you can see from this where, like, millennials came in. Who hasn't experienced this? They're super confident in themselves, regardless of whether they should be or not. They are a very confident generation. And we all heard them say, I want growth, I want flexibility. But they're also the ones that are out there saying, do you hear me? Or do you hear what I'm asking for? Do you hear how I'm bringing value? And so we tend to see them as very needy and needing a lot of attention. None of those are bad things, because they bring amazing skills to the workplace as well. It's just a matter of us having the knowledge to be armed with, to know how to approach them and how to talk to them. Now, your Gen Zers are different, where they're incredibly resourceful, because Gen Z woke up, or they basically grew up with a smartphone in their hand. So this generation are basically just a bunch of walking computers coming into our workforce. So, but they still, as much as they love technology, and technology is an extension of who they are, they want face-to-face contact. So this generation, interestingly enough, and I'll talk about this in the end, is the first one to ever borrow their parents' clothes. And that will come into play in the workplace, but I'm going to make you wait for it so I don't see people dropping off. But their biggest question is, can I trust you? Trust is a huge issue for Gen Zers. And if you think about it, if they grew up with their smartphones in their hands, they grew up with so much information and so much incorrect information. So they question everything. And they question whether they can trust something. Can I trust this source? Can I trust this online video? Can I trust this social media? Can I trust my boss? So I encourage you guys, Jen, you can go to the next slide. These are some different kind of a breakdown, and I only put millennials and Gen Z. I fall somewhere in between an Xer and a millennial, so nothing against the boomers or the Xers. You guys matter too. But just to kind of focus on what the majority of the workplace is right now. And so you can kind of see a shift from millennials, it's all about purpose over paycheck, but Gen Z, it's about money and job security. So we're seeing that come back into the workplace, where it's been gone for the last probably generation and a half. But you see some similarities too, where the technology piece was integral with millennials. It is an extension of the brain with Gen Zers. So we're going to see technology becoming more and more important. If you tell a Gen Zer that they can't have their phone on their desk, that's like severing a limb. So that has a huge impact on them, and something that we have to make a shift as employers. Obviously, there's safety issues, right? If you're in a manufacturing environment, if you're in construction, like, we don't want you operating heavy equipment while on your phone. We don't want you driving while on your phone. But if you make a really hard stance on no cell phones outside of your breaks, even if they're not checking it, but they're allowed to have it on them, that makes a big difference for Gen Zers. Because again, you take that away from them, it's like severing a limb, and that's how they feel. So Gen Zers heavily against politics. They expect change, whereas millennials crave structure. And as opposed to being conflict averse with millennials, Gen Zers are very competitive and very realistic. So we're seeing a return of what I call more of the thinking brain and less of the feeling brain coming with Gen Z. Jen, go ahead and go to the next one. So obviously with the Great Resignation, right, 65% of employees plan to stay with their employer in 2022, which is a very low number. So that dropped another 5%, meaning that the number of employees planning on staying with their employer actually decreased 2022 over 2021. Because there are so many opportunities in the job market, it makes changing jobs less risky. Because if someone decides, hey, I've been here 10 years, I want to try something else, I'm not happy, I'm going to go to another job. And if that doesn't work out, there's plenty more for me to choose from. So there isn't as much risk for them to actually leave the workforce. Now, average compensation increase for those that are leaving right now is 15%. So when you take that into account with what you're currently paying your employees, it makes it very difficult to stay competitive with the rising wages. And I know all employers are feeling that right now. We talk about it all the time. We've got, I used to hire this position at $20 an hour. Now I've got to hire it at 25, but I have people that have been here for 5 years at the same position making 18 because they came in at such a lower rate. So that's something that employers, I would love to say salaries play nothing into retention. They do. So it's something we always need to be looking at, trying to accommodate and trying to offer benefits and create loyalty to make salary less of a concern. So while salary does play a role, it's not the star player right now. So retention, in a recent study, they showed that retention is the biggest management issue of 2022, and it surpassed recruitment, which was the largest management issue in 2021. Next slide, Jen. So I'm going to go through just a couple of different things that you can do. Some of these you're probably already doing, but again, this could be a whole webinar in and of itself. So I recommend once you get these slides, maybe digging into, hey, I feel like I'm appreciating and recognizing my employees, but I'm going to research some things that I could be doing to enhance that, or maybe make it more beneficial to where employees feel it more. Because a lot of times, we think we're appreciating and recognizing people. We think we're knocking it out of the park, and it is just falling dead to their ears. They are not hearing of it. They're not feeling any of it. And so it doesn't matter what we do. So this is something that you kind of always have to be changing. You have to customize for each individual employee. So making sure your employees are appreciated and recognized. 66% of employees say they would quit their jobs if they felt unappreciated, which puts a huge amount of pressure on employers. So the office comes last in the list of places where people express gratitude. So you can see how those two things conflict, right? They're going to quit their jobs if they don't feel appreciated. And office settings and workplace settings are the place where we express gratitude the least. So that's something that as managers, as employers, we have to make a shift on. Signs of feeling undervalued. If you notice your employees are suddenly withdrawn, no longer enthusiastic about new projects or their work like they used to be, or they come to work checked out. These are huge signs that your employees are just not feeling their value in your workplace, and they're not feeling it from you. So building a culture of recognition, incredibly important. Invite managers and employees to write personal notes to their colleagues, and really make recognition as public as you can. So social media is a great tool for this, to give shout outs to your employees. Do it in staff meetings, send it out via email, really. And the more you do that and you encourage your managers and your employees to do it, the more they're going to catch on, and you'll see that kind of build momentum in your workplace. Create an annual awards program where employees are recognized and honored in front of their peers. You can make this fun. You can do it at your annual holiday party. Because I'm positive we're all going to be able to have holiday parties again this year if you didn't last year or the last year before. But and really celebrate. So this line always reminds me of, it's not that different than raising your kids, right? You acknowledge the behavior you want to see more of, as opposed to punishing the behavior you want to see less of. And it works the same for adults. So if there's something that I'm punished for in a workplace, yes, that will resonate with me, but it also has the opportunity to make me feel bitter or to make me feel it was unfair. But if you start acknowledging and rewarding the behavior that is good that I'm doing, then that just incentivizes me to do it more, because I want more of that positive affirmation in my workplace. So that works with your employees the same way it works with your kids. Making sure your employees don't feel overworked and overwhelmed. Good luck. 2020, 2021, hopefully not 2022, have just been brutal on the workforce. And I call it chaos fatigue. And what I mean by that is that it's not just COVID. So regardless of what position you were in the last 2 years, regardless of how much responsibility COVID put on your plate, regardless of, I know for us as like HR and staffing, it was brutal. And it meant long hours and long days and just a ton of stress. But it wasn't just work. It was everywhere you turned, there was chaos, right? There was obviously a pandemic. There was riots and fires and potential wars, and just everything you saw was chaotic in your world. And so in addition to that, real life never stopped. We lost loved ones not related to the pandemic, right? We have problems with kids. We have problems with relationships. We got in car accidents. That may have just been me, but I got in a couple. But real life didn't stop because of COVID. And so we got to a point where we're just fatigued, and everyone just is so tired of, like, everywhere you turn, there's chaos, and that drains you. And so it makes it so that normal work levels that you were fine with before and that you could maintain now become overwhelming. So super interesting to look at the health risks that come with being overworked and overwhelmed. Researchers found that working long hours decrease a person's life by roughly 20%. Now, if you went up to one of your employees and said, if you continue to work at this level, for every day you do this, or for every week you do this, it's going to take 1 day off of your life if you stay in this job. Like, who would stay, right? So these are real things that we need to look at from a standpoint of our employees. So 40% of managers and 34% of employees suffer from extreme levels of stress, which means their job is literally shortening their lifespan. Productivity declines, they fall ill more often, and they make costly mistakes. So things that none of us want. One of the biggest tools for this is open communication. So you need to provide an environment where workers can speak freely about their workload and request the support that they need. You need to encourage workers to take time off, even though that sometimes puts a strain on other staff. We need to build cultures that don't just give vacation and holiday pay and sick pay and flex time, but then make our employees feel bad for using it. You need to build a culture where in previous, generations, it was like, man, you get in here at 6, you leave at 8, like you're the king in that office. Everyone looks up to you. Everyone thinks it's amazing that you're putting in these long hours. But we need to shift that, because it's actually impacting our employees' health and their productivity, and it's going to cost the company either losing them or mistakes that we have to pay for. So really creating a culture where it's like, hey, you know what? You're here from 8 to 5. You take an hour lunch, you do everything you can in your 40 hours a week, and after that you rest. and you take that time off and you invest in yourself and really encouraging employees to take their vacations and not make them feel bad for doing that has a huge impact on that. And a lot of times we don't even realize that we're creating that culture. But if you as a manager put in long hours and your employees always see that, think about the example that you're setting. I don't know how you get around that, except, I don't know, maybe work from home if you're going to do mornings and nights. So your employees still see the example of maintaining the 40-hour work week or whatever your work week is. And then if you need to increase your head count, again, difficult right now. Please don't blow up my phone with your requests. I'm just kidding. We'll take them. We'll find you people. But if it becomes that your entire staff is overworked and overwhelmed, you need to do one of two things. You either need to increase the amount of staff you have, or you need to radically change your priorities in the organization and really do a deep dive. What are we doing? What is it costing us? How can we do it differently to relieve some of the workload? Next slide. All right, I'm gonna have to start flying through these a little bit faster. So improving the onboarding process. Now, this is something that surprisingly, it comes up on every single survey, on every bit of research you do about employee retention, but it's not something that we often think about as being a big deal. Without going into all of this though, I would just say when you have a new employee starting, really go above and beyond to make it a smooth process for them to introduce them to the staff, make them feel comfortable, right? There's things that like, don't have it be like, I don't know how to print. Like my printer isn't set up on my computer, or, you know, simple things like that, that make it harder for an employee to do their job, that are things that they don't want to have to ask you in their first week on the job. And really try to integrate them with their coworkers, with the people that they're going to be working with. That makes a huge, huge difference, because it really helps them become a part of the team. The faster they do that, the faster they're going to be able to contribute to productivity, and they're going to feel like they belong. And if they feel like they belong, they're going to be less likely to be looking for other work. Next slide. So creating career advancement opportunities. Now, this one is tough because for a lot of small businesses, you don't have a ton of positions that people can move up in. So this studies show employees who remain in the same role for an extended period of time are more likely to leave an organization. People don't want to be stagnant. They want to feel like they're continuing to grow, continuing to add to their contributions, but you don't have to make a management ladder the only ladder that employees can climb. So giving them room for advancement with promotions, benefit, and influence, but without having to be a people manager, is a good plan to have. So think of it as kind of parallel ladders that they can promote up. Like, yes, you have a management ladder that actually manages people, but those roles are probably limited and they probably don't turn over very often. So people will look at that and they'll say, well, there's no room for me there. How do I grow? And so giving them opportunities to grow with the benefits that they get, with the influence that they have in the company, and with promotions that are on an equal level, right? So they're still promoting, but they don't actually have to oversee or manage people, which works really well for some employees that aren't great people managers too. So don't have a rigid time structure for when employees can promote. So as long as you're in the private sector, that's pretty easy to really promote based on what they're contributing and what they're bringing to the organization. Create as many professional development opportunities as you can. So pay for them to do courses online. That can be in-house training. It can be online courses. It could be tuition assistance if they want to grow their skills outside of the office as well. And then offer internal training to upskill your workforce as much as you can. Next slide. So creating flexible working arrangements. Again, this one's tough because for most of us, our offices manage, they function better when people are here. And however, COVID just showed an entire nation of employees that it was possible to work remote and they liked it. So we have that to contend with now because they were able to do it during COVID. It worked great. They loved it. And now they don't want to give it up. And we see a ton of corporations that are saying, we're not coming back. We're going to stay remote. So we'll see how long that lasts because it does have its downsides, both for the employees and for employers. So I don't know that we'll see that trend continue forever. But if your industry can allow it, be as flexible as you can, as long as the work is getting done. So allowing work from home on certain days, maybe you do a hybrid where they're able to pick like, hey, I can pick 2 days a month, even if it's as few as that, to be able to work from home and have that flexibility. And allow flexibility during the workday so that they aren't missing those important personal moments. So employees now, they don't want to miss stuff with their kids. They don't want, and that trend was coming prior to COVID. COVID accelerated it because we saw how precious life can be, right? And we all, a lot of us lost people that were close to us. And anytime that happens, we start looking around and saying, what am I missing and why, and is it worth it? So really try to give your employees as much flexibility. And by the way, most of what I'm saying, Jen is probably cringing and going like, you need a policy for that. And she's not wrong, you do, but she can help you with it. So, but giving them, flex time if you're able to, and if they need to go to something for their kids or their parents or they, whatever it may be, that's important to them. If you recognize it's important to you as well, and that their happiness is important to you, and allow them some ability to flex that time, it makes a huge difference. If you give them leeway, you will get loyalty in return, and loyalty is huge. That is one of the biggest pieces of retention that you need to be paying attention to. Some companies are considering alternative work weeks or similar schedules. Working 4/10s and getting 3-day weekends every weekend can be hugely beneficial to your employees if it's something that you're able to do. I know some companies here locally have moved to those after COVID or during COVID and have done like kind of a combination where half of the staff is there Monday through Thursday and half of the staff is there Tuesday through Friday. Either way, the office is open Monday through Friday, but everyone gets a 3-day weekend. So maybe taking a look at that and seeing how can we get creative to give our employees, get the work done. Obviously, that's the most important thing, but give our employees as much flexibility as long as the work is getting done. And then trust your top performers, right? Those are the ones that are really pushing your company forward and are going to keep it growing. You need to trust them explicitly and don't micromanage their time, because those are the ones that you absolutely don't want to lose. I mean, obviously all employees in a company are important, but when you look at your top performers, what would you do to make sure they're here tomorrow? And really think about that and make sure that you're taking care of them and that you're not micromanaging their time and you're allowing them to do what they do best. Next slide. So challenge your employees. And this one's kind of interesting because we don't think of that as a retention tool, but if you're not growing, you're dying, and people don't like that feeling. So one of my favorite books talks about how the only thing that brings us happiness in life is solving problems. And every time you solve a problem, it creates new problems. And that makes me think of this, because if you're not being challenged, if your employees aren't being challenged in the workplace, it really doesn't, they're not going to feel driven. They're not going to feel excited, right? Because ultimately they want to solve problems. And I'm not saying like give them an extraordinary amount of work to make them feel challenged. We're talking about healthy challenges here, right? Pushing them outside of their comfort zone, letting them take risks, showing belief in them, and showing them that failure is a learning opportunity. I think that's one of the most important lessons we can learn in life. And then reward their efforts and not just their talent. Like show them that you appreciate, like, hey, you had this idea, you went for it, I believe in you, it bombed this time, but go back to the drawing board and tell me, like, what did you learn from that and how can you improve on it, and let's try it again. And employees will thrive on that, because not only are you showing that you trust them with that belief, but you're empowering them, and that will help them develop that loyalty that they want to stay with your company, because people want to feel that feeling of empowerment. Next slide. So ask for feedback and act on it. So this is super, super important, because people want to be heard from, they want to be listened to. And this can become super difficult, especially if we go back to the slide about being overwhelmed. Jen, you don't actually have to go back to it, but if you go back to like hey, our managers are overwhelmed, they're overworked, they're at their max, they're handling 50 more things than they should be every day. They still need to take the time to really listen to their employees and show that level of investment. And that means encouraging and listening to all of the feedback your employees give and truly listening to it. Maybe you send out monthly surveys for feedback from your employees on different topics, but make them a part of each decision to the extent that you can. I am not saying everyone has an equal vote, nor should they. I'm not saying that you just, turn the company over and let the employees all decide what they want, because then you're going to go to a hybrid schedule of like one workday. But really listen to what they have to say and try to take that into account as much as you can. And this is where the active listening and things like that really come in, of hear them and help them to feel heard. Using surveys, suggestion boxes, live polls, whatever it may be, to try to get that feedback from them and make it a regular thing. Because the more you do that, and the more employees see like, hey, I wasn't retaliated against, no one was mad at me, and they made these changes because of it, or they came and asked me for follow-up, like, tell me more about this idea. That's going to make them feel valued. And again, that goes back to a key point of retention. Always have an open door, and which my door is always shut, by the like literally physically shut, but my employees know they can always come in here. And I think everyone in the office knows, if you walk up to my glass window panes, I won't even like look in that direction, but I'll see you and either nod yes or no, like I'm on the phone, I can take you or I can't. So Jen and I have to send out an email that says from 9 to 11 today, don't even knock, our doors are locked. But make sure that your employees know you're always available to them, right? They can email you and schedule a time if you're on a super busy day, or just that you will be there and available when they need you, when they have questions, when they need feedback, whatever it is. Send announcements, newsletters, updates as much as you can. Employees want to be in the loop. Unknown and unexpected change causes stress for most people, and it does cause turnover because it gives the feeling of instability within your company, and people don't want to feel, especially like you saw in Gen Zers, job stability is important to them. So that value is coming back into the workplace, and unexpected change can cause stress. Sorry, Jen, go ahead. So what the current workforce wants. So an employer that cares about their well-being and cares about them as a person. Now, again, Jen is going to cringe a little with this HR thing, but people want to be known. Like at a very core of who we are as humans, we want to be known, and your employees are no different. That makes them feel valued. So knowing something about them on a personal level, obviously without crossing the bounds of anything in HR, but knowing about them, knowing their kids or their hobbies, asking what they did on the weekends, paying attention to details in their life, and then remembering to follow up on it. Like, hey, how'd your daughter's graduation go this weekend? Or how'd your son do in his snowboarding tournament? Or what? I don't think snowboarders do tournaments, but you know what I mean? But whatever it may be, to kind of follow up on them. Like, hey, it was a beautiful weekend. Did you get to go hiking? I know you love doing that. And just making sure to have that personal connection with them. They want ethical, open, and transparent leadership. So this one is huge. People more and more are looking to the heads of the companies they work for and the companies they work for and asking, are you ethical and are you transparent? Do I understand what's going on with your company? Do I understand where the company values line up with my values? They want leaders that support a diversive and inclusive workplace. So you'll see a lot of these buzzwords are coming into the workplace, and it's no surprise, right? They want to know if your values are in line with theirs. They want, this is the new one that we'll start hearing, right? ESG responsible organizations. And ESG stands for environmental, social, and governance. So this is where people want to see, right? You see companies getting a lot of backlash for not being green, not being diverse, for backing political candidates, which can be very sticky in this time. because you've got people that are so divided that companies have to really be careful about navigating that gap. And they want a company that delivers on its promises. You got to do what you say you're going to do. And so if you say something to an employee, and in your mind, it may be in passing, it may be, you know, something that you're just kind of thinking about or brainstorming, or it's on the 10-year plan, they don't know that. And so they're going to be watching and saying like, well, whatever happened to that? Like, where did that go? Like, you got to make sure that you're keeping your word. They need to know what's expected of them at work. This is huge. So really having clear expectations, and I'm going to go into a little slide that will help you with that in a bit. Work-life balance that's encouraged by leadership. Again, this gets back to creating a culture of encouraging your employees to rest, encouraging them to invest in themselves. They want a sense of community with their peers. And they want the mission of the company to make them feel like their job is important. People want to know that they're making a contribution. It's one of the biggest motivators for all of us. We want to know that the work we're doing makes a difference for someone. Now, this can be really easy in some positions, and it can be really difficult in another. But maybe that person in your office that's in charge of processing paperwork or doing a lot of just mundane tasks, they just need to hear from their manager, you know what, thank you so much for taking this on. You made my life better. You made my life easier and helped me to do what I need to do by taking all of this. That's huge for them. You can go to the next slide, Jen. So having your managers meet with employees regularly, this really goes back to understanding what's expected of them, having open communication. And these are some things that, you know, we practice within our office. We highly encourage regular meetings of managers with their direct reports. These should be one-on-one meetings, and make sure that obviously you want to document them from a standpoint, not so much of HR, but just for follow-up purposes, because these meetings, and they can happen monthly, they could be weekly, whatever works for your business and makes sense for your model. But sitting down with each of your direct reports and asking them, what are your top priorities right now? What is your manager and team doing to help you accomplish your goals? And then you should ask yourself, am I doing enough to help this employee succeed? And then what strengths are you using to accomplish your goals? What weaknesses are getting in the way, and how are you managing them? What is getting in the way of your effectiveness? And then you ask yourself, how can I better support this employee? How can I remove barriers for them? And then what feedback do you have for your manager? Are there, and of course you would say for me, not for your manager, we don't have to talk about ourselves in the third person, but are there any other items you would like to review that weren't specifically asked about? These are very brief conversations there, but they give you a chance to really connect, touch base with your employees, figure out where they're at, what's important to them right now. And then this helps you define what's expected of them, because this will give you an idea. Maybe what their top priorities are right now are not what you want their top priorities to be, but it hits a lot of those marks in terms of open communication, listening to them, and also making sure they know what's expected of them. All right, next slide. I think this might be my last, maybe not, maybe two more. Okay. So planning get-togethers outside of the office. Obviously, this has been difficult with COVID, but it's something that, and it doesn't necessarily have to be out of the office, but finding creative ways for your employees to connect with each other. Gen Z and millennials want to connect with their peers, and Gen Z not only wants this, but they need it. So when I said they're the first generation to view their parents as their best friend, right? The first generation to borrow your clothes. And I don't know about you guys, but my daughter's home from college right now. She's working, and every single morning she comes into my closet and borrows a piece of clothing and a pair of shoes. And that never seemed strange to me until I heard this in a study, and it makes perfect sense. Like, I would have never worn my mother's clothes. You couldn't have paid me enough money to wear her clothes. But this generation views their parents as their best friends. And they carry that feeling into the workplace too. Now, I'm not saying you need to be best friends with all of your employees. In fact, Jen would say absolutely not. However, nonetheless, you should make it a point to connect with them on a personal level and allow them to connect with their peers. So one of the interesting things about Gen Z is that they will be less likely to leave a job if they're friends with people there, right? Which is really true of everybody, but Gen Z in particular and the millennials, but Gen Z really brings this strong into the workplace where they are social beings, and they, whether they're influencers by the definition of making money, like, man, those kids can post something and all their friends get on board, which is great if you're a great place to work and they love you, because they're going to bring their friends in too. They're going to say great things about you. It helps create and promote that culture. But if they leave, their friends will too. So it's an interesting kind of dynamic that you have to navigate. And then just remember that relationships build trust, trust builds community, and community builds culture. And culture is really what this all comes down to, keeping in mind, though, that your culture needs to ever be changing and adjusting, because your culture has to come to a place where it's going along with the current generation and the trends that we're seeing. Now, okay, so there's a bunch of questions that came in. We've got a few minutes. I'm going to start at the top. So Jen, we're going to need you for these because there's no way I'm answering them. I will just say, for those of you that have had to or need to log off, all of our contact information is on this slide, as well as a picture of our amazing team that makes this all happen. And we will be sending these out. We will be sending out the recording to you as well. And so look for that information, and do not hesitate to reach out to Jen or I if you have any questions regarding any of this information or anything in general that comes up that we might be able to assist you with. So, all right, Jen, hot seat. Do we have to document our employees' vaccination status if we are not in the healthcare industry?
The answer is yes, you do. Because of the Cal OSHA guidelines and the ETS that just was presented, all employees' vaccination status. So every employer should have either an attestation form as part of your onboarding process, or collecting the cards at the time of hire, or, you know, if you've already hired everybody and you don't have that information, you should make sure that somebody on your team collects the data. I would say keep it confidential, obviously, so don't just run around asking everybody their status. Make sure you do it in a confidential fashion, but yes, you need to, even outside of the healthcare industry, unfortunately.
Okay. Can an employee use an at-home test after day 5?
So yes, as long as it's witnessed with somebody, right? So this is back to my point of where, you know, are you FaceTiming somebody? Is it, you know, done with a date and time stamp on your cell phone that you can submit to your employer and let them know? Some employers are a little more flexible about this than others are. You know, I think a few weeks ago, testing was extremely difficult to come by, right? You couldn't go and get, you know, to your local COVID clinic and get a test result back within 5 days. Like, it took almost 6 to 8 days to get a result back from the PCR, the antigen. And so the at-home tests also were difficult to come by. So I think, you know, those are things you have to take into consideration. But, you know, some of the guidance goes back and forth as far as at home tests, are they eligible or not? The ETS says that you can, but it has to be documented somehow that it's witnessed.
Okay. So if all of my employees wear masks around the patients, but one gets COVID, do we need to call all of our patients?
Well, that's a great question. And the guidance says from the California Health Department that in the event that you have an exposure in the workplace, that you have to send out the notice to anybody that was in the workplace at that time. So technically, you should let your patients know that was in the time frame in which they were maybe around the exposed patient, that they've been exposed to COVID.
Okay. So if you have 10 employees and 8 of them work from home, how do you handle the must be posted at the workplace notifications?
So we spoke a little bit about this earlier, that you can do electronic. And if you have like a portal or an intranet or something like that, it's as much as emailing your employee too and letting them know, here's the documents that you need to have in the workplace. These are required that you have, and that you acknowledge that you've received them. I think that's the best that you can do.
Perfect. And do you know if employees can request a religious exemption for the booster when they have already received the first 1 or 2 shots?
Oh, it's a good question. I've never been presented with that. I'd have to check into it and see. I would imagine the question would be is why did you take the first 2 and why now do you need a religious exemption? It might be very difficult to prove if you were willing to do that the first 2 times and now come in. So I would say probably not, but again, I'd have to check into it and see, and probably it's a legal question for an attorney.
Perfect. And now last one, and this one's my fault, so sorry. Flexible work week and California 8 hours of overtime. What is the best way to do that?
Okay, well, so if you're planning to do such as an alternative work week, there's a whole process that you can go through to request this, and you have to do a vote. And this actually will allow employees to work up to 10 hours, even up to 12 hours a day, depending on what kind of schedule you want to do. And you basically are exempting the employee from being paid overtime over 8 hours in a work day. So if they adopt and your employees vote on it and they want to do the alternative work week, they can work over 8 hours per day without receiving overtime pay. That also means they get another day during the week, so they're not working more than 40 hours in the work week. So it's important to do. You do the whole process. You have your employees vote on it. You actually send it off and make sure that you do, I think it's the DIR that you have to send the information to, but there's a whole process and you will be recorded with the state that says you have a bona fide plan to not pay your employees overtime over those 8 hours. But more and more companies, I mean, that was a great point, Michelle. A lot of companies are going to an alternative type schedule, whether it's like 980s, where they're working 9-hour shifts and a part day on Friday, or Mondays part day and then 9-hour shifts during the week. That again would not make you have to pay overtime based on the California rules. Just make sure they have their lunch, their meal period that you've provided, that still by 4 hours and 59 minutes. And I'm not even going to get started on meal periods, but just make sure you provide the opportunity for your employees to do so.
Perfect. And I know in addition to the alternative work week, while that can be a huge process to get that set up and maybe more than what employers really want to commit to, there are some ways that they can just offer flex time for like a couple hours here and there if the employees have appointments and things like that. But again, there's a policy and a form that needs to be filled out when they do that. So if you guys have questions on that, feel free to contact us because we'd be happy to help you with some of that information as well. So I just want to thank you guys all so much for joining us. Thank you, Jen, for an amazing amount of information that you give out on this webinar every year. Thank you to Jake and Todd, who always help us in getting the word out and helping local businesses, but also always take off early. So make sure you give them crap for that when you see them. But thank you so much, you guys. Again, if you have questions, let us know. We will send out the recording and the slides. We so appreciate you guys. We know it's been a tough couple years, but hang in there. We're getting through it. Thank you so much. Have a great rest of your week.
Thank you, guys. Thank you, Michelle. Great job, everybody. See you later.